Madam President, I also rise to discuss the Supreme Court nomination of Judge Neil Gorsuch of the 10th Circuit. I take this very seriously. I started my legal career as an appellate law clerk in the 11th Circuit Court of Appeals in the South, working for a spectacular jurist, Judge R. Lanier Anderson III. He taught me about what it was to be an appellate judge: humility, not making a case a personal cause, careful application of the law. I then went on to practice law in the state and federal courts, the trial and appeal courts, including the United States Supreme Court, as a civil rights lawyer for 17 years. When I was the governor of Virginia, I twice had to appoint members of the Virginia Supreme Court and grappled with qualifications to serve on an appellate bench. And maybe most especially, Madam President, my wife was a judge. So with a judge in the House, she was a judge for 8 years, I spent a lot of time also thinking about the characteristics of a good judge. Judge Gorsuch has some strong characteristics: educational background, professional experience. These are characteristics that are worthy of respect. But I have decided that there's an additional characteristic that's very important: judicial philosophy. And as I've looked at Judge Gorsuch's judicial philosophy, I've concluded that I cannot support him. I have read scores of his opinions. I met with him in my office. I'm so proud of my colleagues, Democratic and Republican, because in 2 months, Judge Gorsuch has enjoyed something that Merrick Garland didn't get in 10 months. Judge Gorsuch has had meetings with virtually all senators. He's had a Judiciary Committee hearing. He's had a Judiciary Committee vote. He's getting floor debate, and he will get a floor vote. Those are the 5 things that he's entitled to, and he's getting all of them. Judge Merrick Garland was nominated. Republicans wouldn't meet with him. They wouldn't hold a hearing. They wouldn't do a committee vote. They wouldn't do floor debate, and they wouldn't do a floor vote. He got nothing. He got nothing that he's entitled to as a sitting judge on the D.C. Circuit, and also the Senate didn't exercise the advise and consent function that is part of our constitutional job description. But let's talk about Judge Gorsuch's record. And many of my colleagues have been speaking for hours. I want to just focus on one aspect of his record. Judge Gorsuch was promoted by President Trump as not an activist. Not an activist. And Judge Gorsuch has written with scorn about activist judges, saying that judges who impose their moral or social preferences on others can't square their position with the Constitution. He even scorned activists in courts, saying that liberals are addicted to the courtroom, as if somehow bringing constitutional claims in courts are wrong. So I think it's fair to look at Judge Gorsuch by his own standard. Is he an activist or not? The best definition of a non-activist judge was the definition given by Chief Justice Roberts during his confirmation hearing. He said, "Look, I'm an umpire. I have no platform. I have no agenda. I call balls and strikes without fear of any party, without favor to any party. I'm an umpire." And I looked at Judge Gorsuch's record and then talked to him about a set of cases to determine whether that was in fact true. And I've concluded that Judge Gorsuch is definitely an activist. He may not be an activist on everything. I don't think you have to be an activist on everything to be an activist, but I do believe he's an activist. And it shows through in no area clearer than it shows through in cases dealing with women's ability to make their own decision about their own health care, especially reproductive health. There's a famous 2013 case that's been much discussed during these discussions and in committee, Hobby Lobby versus Burwell. It was a challenge that was brought up in the 10th Circuit, where Judge Gorsuch now sits. And the legal question before the Circuit Court was pretty straightforward. Under a congressional act designed to protect religious liberty, the Religious Freedom Restoration Act, could a company claim that its religious views conflicted with the contraception mandate of the Affordable Care Act? And if so, could they gain protection for their own position? Now, Madam President, it was sort of a controversial case because the notion that a company could assert religious views was sort of a novel theory at the time, but the majority in the 10th Circuit ruled, with Judge Gorsuch as part of the majority, that yes, a company could assert a claim based on sincerely held religious beliefs under the RFRA statute, and they could assert that their beliefs conflicted with the ACA's contraception mandate. And then in 2014, that ruling was upheld by the United States Supreme Court, a controversial decision, but the majority agreed with the position that, yes, a company could assert that its sincerely held religious beliefs were in fact in conflict with the statute, and they could get relief from the statute for doing that. Judge Gorsuch joined the ruling, which I indicated was later affirmed by the Supreme Court. But what interested me about Judge Gorsuch in the case was that he chose to write a concurring opinion. Now, for folks who, most folks know what they are, but if you're not a lawyer, when a panel writes an opinion, there's a majority opinion that is the ruling in the case. If a judge feels that it's wrong, a judge will write a dissenting opinion saying, no, you're wrong and here's why. And you're sort of duty-bound if you think the majority is wrong to write a dissent. But a concurring opinion is about as voluntary as it gets. A concurring opinion is, I agree with the outcome, but I just have a point that I want to make that I can't convince the rest of the majority to go along with me on, and I want to make this point. And so Judge Gorsuch wrote a concurring opinion that was incredibly revealing. It was voluntary, and that shows you a little bit about a person's philosophy, incredibly revealing. Revealing for two reasons. First, Judge Gorsuch had already joined the majority opinion to say that the employer, Hobby Lobby, could challenge the employer mandate of the ACA. He'd already joined that. But he stretched beyond to rule that, in addition, the individuals owning the company should be able to sue to challenge the employer mandate, even though they weren't the employer. The ACA mandate only applied to the employer of the female employees. The employer was Hobby Lobby. But even though the mandate didn't even apply to the Green family that owned the company, Judge Gorsuch said they should be able to challenge the ACA anyway. I practiced law for a long time. There is a complete separation, there's supposed to be, between individuals and an incorporated company. You can run a business and not incorporate it, and in that case, there's no separation. But as soon as you incorporate it, you get all kinds of protection, especially you can protect your own personal assets from liability for corporate actions. The Green family had done that, but Judge Gorsuch said even though you voluntarily separated yourself from the company, and even though the mandate doesn't apply to you, you should be able to file a lawsuit to challenge the mandate. I found that to be highly, highly unusual, a great stretch, and I asked him about it when we talked, and he did not give me a satisfactory answer. But here was the thing about the Hobby Lobby case that was more notable. It was the way that Judge Gorsuch described what the case was about. The majority opinion in the 10th Circuit and the majority opinion in the Supreme Court described the case the same way. They basically said, the owners of this company claim that the contraception mandate is contrary to their religious views. That's what the case is about. The clash was between the owner's religious beliefs and the statute. That's what the case was about. But Judge Gorsuch described the case completely differently. Here were his words. All of us must face the problem of complicity. All of us must decide the degree to which we are willing to be involved in the wrongdoing of others. He didn't describe it as a clash between the owners and the statute. He described whether you're willing to be complicit in the wrongdoing of others. That wasn't the legal issue at all. What does that phrase mean in the Gorsuch concurring opinion in Hobby Lobby? The wrongdoing of others. Who are the others he's talking about? He's talking about female employees of Hobby Lobby who wish to make their own choice from among available and lawful methods of contraception. Those are the others. He's also referring to that choice as wrongdoing. That is a completely editorial comment. That's not drawn from what a lawyer said or what a plaintiff said. That's his own characterization of the case, and it is completely irrelevant, and I would argue insulting. It is a completely irrelevant and insulting reference to something that wasn't part of the case at all, except Judge Gorsuch decided to inject it into the case. Somebody who looks at women making their own choice of contraception as the wrongdoing of others, that's very telling. Point.
Senator, the time for the Democrats has expired.
President.
Majority Whip.
If my friend